Let us turn at 5 to Wendy Joseph KC, former Old Bailey judge, author of Rough Justice, Do We Have the Law We Deserve? Thank you for coming on, Wendy. Is this the punishment that Rudakubana deserves?
Well, it's what Mr. Justice Goose has said is the right sentence. It's an exceptionally long sentence for anyone, never mind an 18-year-old. But these are, as the judge said, quite exceptional offences. I can't think of another set of offences like this committed by anyone of that age.
The judge talked about discounts to that sentence for the guilty plea, although very late, and the mitigation because of Rudakubana's age at the time of the offences when he was 17. And I wonder whether, Wendy, listening to the offences that he committed and what he intended to do to those children, I wonder whether you could explain why there needs to be any discount, any sort of offering of solace for this killer.
Very little solace there, Tom. I think Mr. Justice Goose did not spell out the amount of the discount. That is in effect because it was probably pretty negligible. The reality is that you don't get large discounts from pleas to murder in any event, even if they're early pleas. But this was such a late plea, it could barely have come later. It was on the verge of the trial itself. He will have got very, very little discount for that. In fact, I think what was notable was how short the mitigation advanced by the defendant's own barrister was. Very little was advanced to try and reduce this sentence, and that's why the sentence was what it was.
And I'll put it to you, Wendy, that the questions about how this horrific crime took place are going to be attempted to be answered by a public inquiry. There is a question, too, that lingers about the notion of a cover-up of the information that has now come into the public domain about this man's history. What do you make of the government's answer that to have put that information in the public domain at the time that the government was aware of it would have prejudiced this trial?
Tom, I just don't have the information to be able to say anything sensible about that. What happened after the events themselves, after the killings themselves, seemed to subsume everyone's mind.
But is it right to say, is it right for the government to say the trial could have been prejudiced by the information that he was known to prevent being made public before he was charged with any terror offences?
It's possible. I just don't know, because I don't know what the CPS had in their minds about charging terrorism. It's a strange argument because, as I understand it, Prevent had made the firm decision that it wasn't terrorism, and that's why they refused to handle what was then a boy. But I just don't have the information, Tom, to be able to give you a sensible answer.